Welcome viewers to the latest Waterstone book review.
First book review.
Well, first book review. Damien's fresh back from that eye doctor, so he's ready to go. He's camera ready.
And the fact that my eye pupils are dilated is not a result of me being high. We just want to be clear about that.
And the book we're here to talk about today is A Simple Nullity by David Williams, and it's about the Wi Parata case and New Zealand law and history. And Damien's obviously read this book, I hope.
I have.
And we're here to give a high-level review on the importance of this book and on this case and what it actually means. So, Damien, why don't you jump in with the helicopter view in terms of this book and what it really touches on?
Well, I became aware of the case because the phrase "a simple nullity," which is in reference to the Treaty of Waitangi, came out of an 1877 case. And I used that in one of my stuff columns, and a correspondent brought to my attention the fact that this book existed. And so David Williams, who is a Rhodes Scholar, and as per chance I actually interviewed him when I did a story on Rhodes Scholars, he wrote a book, and the book's about 10 years old now. He wrote an entire book on that simple case, that story. And the thing that jumps out, so the phrase "a simple nullity" has been interpreted, I think, incorrectly by people critical of the judge, Pendergrass, saying that the judiciary at the time, 1877 and thereabouts, treated the Treaty of Waitangi as a simple nullity, as simply a document of no moment and of no importance. But what David Williams is saying, and certainly I read the case, and it's quite a small case. Some of its language is fairly confrontational now when the way that they're talking. But what the judge is saying is that what was a simple nullity was the fact that, in the judge's view, native title or Maori title existed before 1840 and was undisturbed by the treaty. So if you had title in 1840, the treaty was signed, that title still existed, that native title still existed after 1840. And that's what the judge was talking about when he wrote the term "a simple nullity." At least that's how I interpreted it.
So why should we care about that difference of interpretation? What does that actually mean for us sitting here, fast forward 2022? What's the importance of that distinction?
The issues continue to play out. So the case revolves around a chunk of land. And so what happened was that the local Maori said to the local bishop, effectively the Anglican bishop, "We will give you this land, and in return you will build a church." Well, the Bishop of Wellington reneged on that deal. But at the time, Crown had a monopoly on acquiring native land. So the tribe had to gift the land to the Crown. He then gifted it to the Bishop of Wellington. When the tribe attempted to get it back, it went to the Supreme Court, who was equivalent to the High Court, and the High Court said no for narrow technical reasons, because the Maori had no claim against the bishop, they only had a claim against the Crown. So, but you actually see that
because of the pass-through and the way in which it went.
Effectively, yeah.
Okay.
So the Maori may have a moral right to the title, but they had no legal claim. Now there was subsequent settlements done, and one of them is the Witiari Polytechnic, and you actually see it. That when you see that out there, that is a direct result of this case. How much of that case actually resonates today in contemporary law, I don't know. But the thing that I really enjoyed about this case, is simply the characters involved. My goodness, these people are fascinating. So the individual Wi Parata himself is a gentleman of mixed ancestry. He was involved in colonial politics. He was on the executive council, so he had a very senior role inside the colonial administration. Nonetheless, though, he was still involved in his local iwi. He left politics, he left colonial authority, went back to his iwi, and then took this case and charged it through. And so it's just so interesting when you go back, and so we have this view of how of what our past was like. But when you read these stories, that's not the way it was. The interaction between the Indigenous and the colonial authorities was just so fluid, and it's fascinating. And there's Te Rauparaha and his children make an appearance in the story. It's fantastic. But probably the favourite character for me in the story is a guy called Edward Barton. And this guy, he was the lawyer representing Wi Parata. He was a bit of the, some people remember Yevgeny Orlov, who was an enormously colourful lawyer in Auckland. He now practices tax law in Panama, but because he unfortunately had to leave the legal profession after some antagonism with the judiciary. Well, this lawyer Barton was the same, and at one point he essentially accused Pendergrast, the Chief Justice at the time of the High Court, of exercising bias. Pendergrast was so angry, he slapped him in prison for 30 days. So there was Barton sitting in cooling in heels in jail for 30 days. At that same time, a vacancy arrived for the Wellington seat in Parliament. Barton ran for the seat whilst an inmate at Mount Crawford, and he won. He then went from a prison cell in Mount Crawford into Parliament and remained there for the duration. It was about 18 months. The characters in the story are fascinating. It's a great story. And David Williams, who is a professor and a Rhodes Scholar at Auckland, and it's just interesting the amount of work that went in just on that one simple case and the ramifications. Williams even goes down to analyse, in his view, Pendergrast, there was two judges, Pendergrast and Richardson. Williams actually goes into the minutia, looks at the original paperwork and comes to the conclusion that Pendergrast wasn't actually the author, it was Richardson. So to answer your question, how much does that case still resonate with us today? It's a bit hard to know, other than when you see the phrase "a simple nullity" being thrown around as a slur against colonial authority and judges.
Essentially, were they trying to use that like a crutch and say, well, look, the judges way back when were saying the treaty was a nullity, so that was their view all along. Is that the kind of way it's interpreted?
I think there's an interpretation that because Pendergrast in his judgment said that there was a simple nullity, that colonial authorities treated the Treaty of Waitangi as something of no moment, as something that could be thrown in the bin. But when you read the judgment and read David Williams' book, that's quite clearly not the case. The local authorities and the judiciary view the Treaty of Waitangi as an important document, not to the extent that we do now. I don't think they saw it as the founding document of the country, but they certainly saw it as a document that needed to be considered. But in this case, what Pendergrast was saying, and this is so important, that Maori owned land in 1840, they signed the treaty, and they still owned the land. And in a lot of sense, a lot of what has happened since then, when native land was expropriated and taken all manner of dodgy dealings, some of those issues are obviously still being battled out as people attempt to reassert control and power. And you could argue that we see a flavour of that in co-governance and so forth.
You've made it clear that your position is that you agree that there should be compensation for land that was taken.
Oh yeah,
fairly,
I'm a hard, because it's property rights, right? So my view is, if you own property and the Crown comes and nicks it, then the Crown has to compensate. And so I have absolutely no sympathy for people who say, oh well, they lost the land, it was 100 years ago. Who cares? Property rights matter. But there are so many other things that are interesting. So one of the other arguments that we don't really have anymore, but that was coming through in this book, you talk about the Ngāi Tātou in the South Island, and I made a joke about that in my column. The local iwi, because they actually only controlled a really small amount of land physically, right? They had no real control over the Remarkables. But under the colonial system that existed at the time, under the British concept of law, it doesn't matter that no Maori had ever walked across the Southern Alps. They were there first, and that was their land, and they had title to it. So if the colonial authorities wanted the Remarkables, then they had to do a deal to acquire it. And that was a hotly contested issue at the time. So there were countervailing views saying, well, hold on, how can the local iwi, who's never been anywhere near that mountain, claim it's theirs? But the countervailing view as, well, hey, that's how in colonial times that was a British system
it
of land law.
wasn't conceivable that land could belong to no one, I guess, for the British.
Yeah, that's a good point, because of course in Australia they did have that concept. They said it was terra nullius, and so in Australia they just kind of pretended the Aborigines didn't exist.
Right.
Well, whereas in New Zealand the colonial authority didn't do that. They acknowledged that the local Maori were there.
So, in terms of this book, out of 10?
I give it an 8 out of 10.
Out of 10, so that just scrapes onto the must-read list for our Waterstone book review. So if you're interested in the context of,
it's a really
the
good
early
read.
court's interpretation of the treaty.
And the characters. Some of these, because it goes on, some of these guys, they went to Victoria, they went to the goldfields, they had an argument, they ran for the Victorian Parliament, lost the election, came to New Zealand, ran for Parliament here. The wild west of our colonial era is fascinating, and a lot of the characters turn up in this book. So yeah, 8 out of 10, strong recommend.
All right, well, look it up. A Simple Nullity, David Williams. And
Still in print.
Catch us next time for our next book review.
Thanks.
Right.